your rights and duties to things and to people. In English law, every citizen accepts a land tenure contract, and it's a part of what's called municipal law, and that turns you into a corporate person that gives you titles by purchase. Littleton gives a very good diagram on the actual tenure itself. Everything in this red box at the very top are all the people with all the individuals with a use for a fee. And all of these individuals in this top box will require a release to release the things that they have a use of for a fee in order to remove the municipal law disability. Because in municipal law, being a corporate individual, as in a citizen, is a disability in law that bars you from everything in the blue blocks. Everything at the bottom of the page, as you can see, there's a box in here that is a different type of person or an individual. As you can see, this splits into two ways. One is basically a legal right, and this is more of to the equitable use jurisdiction, the laws of the government, and so on and so forth. The bottom here is how the title of the king is actually split up with the authority between the Lord spiritual and temporal, and how that all portrays. You'll notice that there's numbers for each one of these. This corresponds to a different section within commentaries upon Littleton that explains each one in detail. This discussion is about releasing the corporate rights, duties, and actions to be so you can stand as the natural person and not as the equitable corporate person that only has a use for a fee. If we look at this a little bit closer, we can see that it takes you through the different areas of law, and when you follow it back up and around, you can see that a release can be done by law itself and also by the parties. So when it's law by itself, it takes you to an indefinite end right here. When it's a release between parties, we see that it has to go through a bunch of other procedures to actually get there, because as we will understand by English law is all trust law, because you as the donor granting to the monarchy makes the monarchy the first trustee and the start of English law, which is all trust law. And then the monarchy is assumed to be the owner because of trust law, which when you grant a trust, the trustee becomes the assumed owner in law in order to be able to deal with that instrument or that thing. So that's where the issue comes in by people believing the monarchy created the government and the individual grants a land tenure to the monarchy, and the monarchy created a corporation that you have to accept that corporate person and to accept that land tenure. So in order for you to get that, to be in a standing in the proper capacity as donor and not as an equitable individual in fee simple, you have to release the things that you hold before you can actually release that job. Let's look at it like you work for a company and they give you a truck and a whole bunch of tools and everything, but you have to pay a monthly fee for the use of those tools and the truck that comes directly off your wage. when you want to quit that job, everything has to go back to the company before you can quit your job. So you have to take back the truck and tools. So that's basically you're releasing all the tools back to them. You get a signed document confirming that they've released you from a legal obligation to those things, because now it's back in their care and they're confirming that. So that's where confirmation comes in. And you'll notice that a release comes into play whenever anyone releases. So that confirmation also is acting as a release, because they're releasing you from that liability, from that thing that you were holding. So now that you've released those things, now you can quit your job. So now you can release your job again, right, as being that corporate person, and then they release you and give you confirmation, right, your record of employment and so on and so forth. So as you can see, all these things work the same way within reason, within common law and equity, and that's the two jurisdictions being mirrored. And we'll be getting more into that, and if you've been paying attention to the things on omnipotence, you'll already kind of get an understanding of that. So I guess what we should do now is jump into the release, and we'll do that next. Okay, I guess it would be a good time to pause and jump to the next one, no? If you guys have any questions?
Yeah, we're paused. Do you want me to just stop that one and we can start a new 10-minute?
Yeah.
Yeah. We'll start. I guess with questions of that first, of what we just went over. Is this way, if Chris or any of you guys want to ask any questions, we can ask some questions, and then we'll move on to the release part of it.
Hey, William, do you think with the other diagram, since it was inside the squares, I could break those down, those squares, into 4 different little screens so they all fit on the screen at the same time? Or, I mean, one section at each one, and then that could be a thing where you could break down each one. Is that right?
Well, yes, and that's kind of why I was hoping to find somebody that was good with like GIMP or Photoshop or something, so we can actually, because for the website, if you make it in GIMP, every layer you can have a link to it. So the layer, because I don't know if you guys are familiar with Photoshop, but it's like same thing as painting a picture. Every color is a different layer. You can make every color a different layer, right? So you can make, because you guys are looking at the screens, at my screen right now, so of lands, you see what I'm getting at? So you can do what you can see on the screen right now as one piece, and then each one of those pieces can be clicked on and open up another one and take you and give you a real diagram for the entire thing for today. Because you got to remember, this is just commentaries upon Littleton. This is everything. We don't need everything in here, and we also need more than just this, because this is the ancient land, I should say the feudal land tenures, and getting into the ancient land tenures, right? Where Coke upon Littleton is getting more into the ancient land tenures, right? And then Blackstone's dealing with the modern land tenures, right? Because one created the next, and right, and so on and so forth. So that's the reason why we're having to start here. So if we can somehow take these into, because we can, if you actually look at these a little bit closer, you can see that we can actually break this into a better diagram that goes up and down instead of side, and it would lead us into it would be a better understanding, because then you could even color coordinate the backgrounds for what is the equitable areas and what's for the common law areas, and so on and so forth, right? Like we can because the biggest problem with all these books is they're written with the assumption that you understand all this stuff and you agree to it, right? So that's why it's all mixed together the way it is. And in these charts, they're actually separated, so we could do each one in color coordination and everything else to make everything completely understandable throughout everything, because every area would be the same color, right? Like everything that's in common law, we could make it a nice earth color, right? And then equity, we could make it like a dark bad color type thing, right? You kind of see what I'm getting at.
I have a suggestion. Maybe this will work, maybe it won't. But when you were teaching Justin and I a little bit about how to use a website and everything, you brought up or maybe it was just me, but you brought up like a paint program, and you started to show how you could put boxes inside of boxes. Do you remember what I'm talking about?
Yeah.
So if you were doing this, like giving us a short presentation, just a real short on something, and use some of these things, and instead of showing this, we could flash back to it because you have tabs, right? But instead of showing this, you showed us a paint picture, your paint program, and then you made a box and you typed in from this part of the box into that box on the paint program as you're explaining it. Would that make, in other words, if you could show us what you want to do or how you think this could be laid out, I think we could copy it if we had an example. And then we could do the rest of them for you all. Each one could do a different one, and we could get it all done, and then we'd have them.
Okay, yeah, I see what you're getting. Yeah, I could actually. I don't know if I can do that quick enough as we're talking and everything, right? Because
I know if you could cut and paste, it could be easier, but you can't cut and paste off these documents, so that's the problem.
No, you kind of got to do screenshots. That's the thing, right? So,
but the reason I was saying that might be a good way to go, at least on a short half an hour deal, is because if you could show us how to read these charts, then we should be able to break those and make those graphs ourselves, and we can just upload them to the site. If they need change, we can just go back to our file and change it, whatever it needs to change.
It's already done for us, though.
I know. See, it's already done, but we just have to know exactly how it goes. Like you said, some things aren't needed.
Well, you know how, like, you got a picture, like this picture here?
Yeah.
If we could... Oh, there we go. Like that. And change all the words so it goes down.
Okay. But isn't there like where the red squares and the blue square and the red square? Wouldn't those be one frame, or do you need to see the whole thing at one time?
Well, that's kind of what I was trying to simplify, because if we zoom this out, if you notice that they're just using a sentence on each, right? So if it was turned this way and the writing all went the same way as Littleton's tenures, then it would be a lot easier to, right? It would be a lot easier, and then you can color coordinate the backgrounds that go with the proper ones and keep following the same format for every single one of them, right? I can't flip this book to show you what pieces would look like. You see what I'm getting at? So it would be a lot longer, right? You see what I'm getting at?
Yeah.
Like, it would be a lot longer, like it would go down farther, right? But it would be easier to understand.
In other words, what we could do is, these are sideways boxes, but if we pretended that they're up and down, then we would take the one that's on the very right, basically move it over to the left and go up and down with it, and then put the other ones up and down next to it, coming out to the right. In other words, it'd be like, instead of 4 columns down, it'd be 4 columns across.
That's right. And all we do is take these words here, because it's coming to this edge here. Take these words here, flip them around so they go this way.
Right.
Take this one here, leave it right there, just flip it around so it's this way. Same with this one. We just flip it around and so it goes this way. So then we can, right? So then we can make it so it's actually clickable, because if each one is done in its own layer, you can say, right? Its own box, it can be clickable. And so they can take you right to the book and to the page, right? Because by us having everything on the server, we can do the pound page equals and add the page number. So then as soon as they click on it, it takes them right to that exact page. Or you can have a picture, or it can take you to an article or a blog or whatever you want, right? Or it can even be a pop-up for a picture. Right? So when it's right, so when it's something important, like I'll have to turn because I can't even read it sideways. Right, because like when you're getting into like like freehold, right? People don't understand what freehold is. So if you made a single page explaining what freehold was and tracing it from the ancient land tenure today, when they clicked on that, they'd come to the article and it would explain it all to them in one shot, right? And same with the different estates, right? Yeah. Of inheritance and freehold, because this is the estates of inheritance are the people that can claim and get their estates back. These ones can't.
Yeah.
You see what I'm getting at?
Yeah, and I understand it much more better now. I'm glad you explained that because I get the whole idea how it branches out. So if we need it on one page, though, it's like estates. You're saying they could be on the same page because we only need these major topics levels, which is what they've already done. Like say the major topics is estates with inheritance and freehold. Those are the big ones, and then the minor ones will be over here. But it's very important, right, that estates has to be tied to the land of freehold, too, one more back. So how much do you put on each page to make sure that you got the whole gist of the whole thing? But I can see it now a lot easier.
But that's where the rest of this line takes you.
Well, I was talking about going back below estates. So before estates, the estates is on the high, right there where you're at. That would be the major part. The land of the freehold is the major part. Then over here, it goes up to estates and then over to freehold. So.
No, remember, look at it. Even actually, I'll have to flip this. The start is actually right there.
Yeah, right there.
May be divided into two parts.
Right.
So remember, you're the donor. You're right here. Mm-hmm. What happens as soon as you give it to the monarchy? This is the title being split into two right off the hop. This is our diagram to teach everybody how it starts. And this is all we have to do is just this one page. And if you explain everything on the page how it goes right to the end, right? I'll go back now. That gives a much better, right? So it starts here. It splits into two. So the king holds the lands. All these people are holding the lands in trust, right? Everybody on this side has right? This is the people. Right, because you got to look. That's for lands of freehold, and this is for chattel. So this is the use side, right. The equity. Right, you see what I'm getting at? Because look at here's your real and personal, and it's all to do with chattel. Because you got to remember, English law is not over the individuals; it's over the things. Look, it's land of freehold and chattel.
Right.
Right, so it's super simple. The English law is not over people; it's over the titles. Look, titles of. Right, so and then over here, look, it looks a tenure, the service which are as it were the bond betwixt between the lord and the tenant, whereby the lands are held to, right, the king. And other lords also of these tenements, which are spiritual and temporal. Remember, I keep telling everybody the spiritual and temporal are two separate jurisdictions, spiritual and temporal. All right, the and is telling you just like this. This is the law. This is the equity. The titles of is equity. See what I'm getting at? The law is
very easy to chart out. Really, it's already charted. We just have to put it in a way we can look at it on the screen.
Exactly, and then the releases is the exact same thing because I can't turn this one right, but if you turn add here and Look at this. The making of them, which is to be considered, right? And then on this side, you have the effect. So, so we already see how to make it, and what the effect is, right?
Well,
and if we keep looking at this a little bit farther, right, on the effect of the release, how it is unearthed, right? So how you can do it, and how it is depleted. So when we actually look at it right, so it gets simpler the farther we get into it. What's the complicated? Because what page was that you guys wasn't it 447 or something? That was really big. Or was it 497?
447 was the deed. It's right there at the top of that box at the bottom there. I see it.
No, but when Kev, you were saying something about hope we don't have to do that one big section. Same with Justin. They were saying something.
463 it was. Section 463.
460.
There's another one. I can't remember which one mine was. 436 or 464, something like that.
Yeah, see, and then if we look, here it is here, 463, and that's because, we're talking about it's getting it into privity, and also unless it be between full fire and full fie upon confidence, right? So now it's talking, because back then, that's why the first part on the fee simple and I should say the life estate and all the different types of subjects in English law is important, because back in the ancient land tenures there was lord barons, there was knights, there were sergeants, you kind of see what I'm getting at, and each one of those individuals in that class were bound by different laws and had different restrictions and so on and so forth, right? So basically, to sum it all up, all of those are now wrapped into fee simple in today's jurisdiction. But to understand how, because it's the same one, the release of military service is the same today as it is in the ancient land tenures. So if you were actually in the military today and you wanted to get out of English law, you would be more focusing on the release part for the corporate person for the military section. You kind of see what I'm getting at? Because that's more where you would be falling into. But since 99% of us are just going to be basic fee simple individuals and we're not going to be performing a function of government, we really only have to look at the tenant of life estate. And that also brings us into that very first picture of the deed, of the tenure, of who gets inheritance and who doesn't, right? Because the corporate person doesn't get an inheritance. But the fee simple absolute is conveying two things. It's saying that you're seized of it, but as long as you give up your corporate person, you have that warranty to it, because you had to give those lands to become fee simple. You see what I'm getting at? So if you didn't give the lands, you wouldn't have an indenture. So as soon as you have an indenture, like a live record of birth, you've been seized of your lands and your inheritance. So that's why this release is so important to understand. Basically, almost to breeze through kind of all those different capacities in Volume 1. And that's why Littleton goes into them also in depth, is because each one of those in the next jurisdiction, like in the next jurisdiction up, I believe they, like all the military service and the barons and all that kind of stuff, they all got wrapped into a different jurisdiction, where life tenants were still in theirs, but a bunch of the other ones got combined into another one. And then by the time we get into municipal law today, all of them are combined into fee simple absolute by the Law of Property 1925. So That's why.
all the barons and all the lords were made fee simple in 1837 through the Wills Act.
Exactly. And then by 1925, it was incorporated through all law of property. So anybody that held a piece of property in English law.
Right.
So that also helps us, because that means that even a judge, it doesn't matter who they are. If they're in English law, they have an indefeasible title to the donor, to somebody in their natural capacity, not in English law.
Okay, and that relates a little bit to the conflict of laws book that you pointed me to, where like a state, for example, doesn't have a human superior, but within the municipal laws, the private laws, there's the human superior. Is that right, what you're saying?
Throw that out one more time.
You were saying that the judge, for example, or a lord or a baron, is still subject to the donor. So in the conflict of laws book you've pointed me to, where they're describing the public law, which would be the state, for example, which has no human superior, but when it goes down to the private laws, it's describing them as the humans are the superior. The judges, for example, still have a human superior. So that would then correspond with, for example, their fee simple.
Exactly, because everybody in fee simple is a dead corporate fiction. They're not working in their own right.
Yeah.
Right? We're a natural individual, us in private. And another thing that I got to really point out is there's private and public in civil, like in equity, and there's private and public in natural law, like private international law as well. The public law is government law in private international law, and private law and private international law is you as sui juris, where you own your own lands and you're not in an equitable contract with someone else, giving up those rights. Right? Well, you actually don't give up those rights. You're putting a contract between those rights that takes that takes priority over your natural rights. So they never take your natural rights. They're always there. They just made it so. Well, even in natural law, it's just a natural law. When you make an agreement with somebody, you agree to that. So that supersedes your natural law, right? You kind of see what I'm getting at? So that's kind of where that comes into play, that whenever we go and make an agreement, we put that between us and our natural law, right? So if you make an agreement that you're going to do this before you do anything else for yourself, well, you put that agreement between anything you have to do for yourself. So that means that you have to do that before you do anything else for yourself.
You can't kind of use natural law to establish the agreement. You know, you're using your own free will, aren't you?
Exactly, and that's why they say that English law is based on natural law, because it's based on natural law, but it's not, and that's what they base it on, because this is all written. You do have a choice. There is a way out. It is also written, and it's written in excess. Once you start looking, once you actually find the right area of law, there's so much you can't read it all. You literally can't read all the law that's out there for reversion law. It's just too much. Right? So it really depends on your capacity, and that's why this release is so important. Right? Going back to, right, if you're driving around in the government hydro truck and still using all their tools, guess what? You're working for hydro. Right? And until you give that stuff back, you're going to keep working for hydro. Right? It's just that simple. And that's kind of the position, and that's kind of where they've got everybody double whipped is because everybody thinks that they actually own all these things, right? Because in equity, yes, you're the assumed owner. You're not the true owner. You're the assumed owner with a defeasible title. So when the true owner comes back, the one that's donor, right, acting in his proper capacity, right, you've thrown away all your money, right? Everything that you purchased it for. You didn't have to purchase it. Is basically what they're saying. And
Isn't that the reason? Isn't that the reason why it calls it a tax return? In other words, you're due a return of all those taxes because really they weren't for you; they were for the corporate body that you using. So they give you back the taxes that you pay because you weren't supposed to pay those. It's almost like a business expense. You know, when you go out and buy stuff, you're working for a company and you have different expenses for them and it comes out of your pocket, then you just give the receipts back to the company and then they pay for it. They return your money for what you paid because it was a company expense.
Exactly. And then if we look at what the natural law is, your natural rights are only three things: life, liberty, and land. Right? All these other things everybody talks about, those are all equitable rights. Those are been granted to you by somebody else. Right? And they've been granted to you because you accepted them under a license. Right? Where the donor, because you got to remember, these are all proclaimed laws. So when you accept them under a license, you joined that group, and now you're bound by them. But when someone proclaims something, and you don't, in your fiction, because they're at the top of the hill screaming, they're not going to do these things to you, but now they're doing them to you. You see what I'm getting at? So that's where the difference comes in. And then if we look at where I brought my screen to here, the first thing that the release is talking about is in the matter of, right? Because in the matter is the other way, like in what form you do it. Now, the subject matter to it are two things: of lands and of other things. Right? So if we go back to the very first picture, right, we see that the very first thing, titles, right? And then if we go to the releases, look at that, boom, of land and of things, right? So you're holding, once you give your lands away, right, now you, right, because if we look at the acceptance part of it, because we already know the acceptance is by livery by cession, so that's accepting titles by purchase, right? So if we look at this part, because of lands, it stops, right? It dead ends right there, 444, right? And if you start looking at the things, because this is another section, right? This is really making sure that you release those things, because you got to remember that this is explaining the other side of the coin, right? This is they're explaining it in the fashion that your acceptance and you know about all these things, right? So we got to keeping that in our minds as we're reading it, because only certain paragraphs are just going to be jumping out and then boom, it's going to be just blunt. And it's going to be just in a paragraph, maybe even a sentence, right? For the answer that we're looking for this. And you will notice that it all has to do with things. And it's real and personal, right? And then either of these is a bar of mixed actions. Look at that, waste and asseise, right? So because we're already familiar with the actions and everything else, we can already see what's happening here, because this is split into real and personal, right? When we go to this, right, it's also split into real and personal, right? Tenant for years and a tenant at will, right? One is certain and one is uncertain. You see what I'm getting at? So,
hey, William, why is the real and personal not also split? Go back to the real release
real
one.
is there.
Oh yeah, I see it split on that one, but go back to the other one, on the release page, the other page you showed, the black and white. See up there at the top, it has real and personal, but they're both together. They're not like resplit again.
because you got to remember that this is only equity, just like here. See, boom, chattel, that's this. Real and personal. You notice real stops here, but personal continues.
Yeah.
So you get that answer by this, by who the capacity is, who's holding them, and what did they agree to hold those things. See what I'm getting at? And that's why release is right here. It's right. This is that, right? Your equity section, and this is how to borrow them. All right. And I believe I even have that one, right, in a screenshot, because it's powerful, right? And that's releasing all of the rights, duties, and actions, personal and real. Here, as you can see, I've got a lot of them already. What number was that? 497. $497. See, and it goes right into it in the same manner, right? Of things personal, as if a man by wrong take away my goods, if I release to him all action personal, yet I may by the law, take my goods out of his possession. See, so this is giving extreme amount, like it's going right into the heart of why they have to give those things up, right? And it's attached to the capacity on the individual, because you got to remember, he can't say donor and so on and so forth, because they're using they're writing it in a way that this works whether you're in common law or equity. So it all determines on your capacity in law to have that thing, and capacity in law on how you're holding that thing, right? So that's why I keep talking about those 3 levels, because everybody's bound by a law, right? And everybody's bound by a different law, right? Because you make different agreements than I make. So even within the English law jurisdiction, everybody's bound by a different law. A judge takes on extra agreements than anybody else, and so on and so forth. So when we're actually looking at this, we got to remember that these terms are made, like just like decisor for fai for fior. Their definitions determine on who you are and what capacity you're in. Because if you're in fee simple, it means something completely if you're in the capacity of a donor.
Yeah. So you could basically track anybody starting at the beginning, like say with a red pen, and just follow them through the lines all the way to whatever they've done, depending on their situation, and figure out where they are in the law.
Exactly. And it all starts by just asking them 2 simple questions. Where do you live and what do you do for a living?
Yeah.
Right? Because what you do for a living is going to determine if you have any other contracts than the basic individual citizen, right? Because if you say, well, I work for the RCMP, well, hey, guess what? Now you're performing a function of government, and I now know that you're bound by the laws that class of subject has to abide by, right? If he says a judge, well, okay, well, if you're in a corporate court, well, you obviously know that he's bound by the corporate laws, right? And if he's a Queen's Bench judge, well, you know he's bound by the Queen. He's acting as the king or queen himself. So now he's your trustee, right? So he has to give it to you, right? And if he doesn't, then you have a writ of error that goes to the Supreme Court, and then the Supreme Court takes all his things and gives them to you. If you know the writ to file and the information for that remedy, if you know that that's what the law says, and you can prove that if a judge doesn't give this to you when you go up to him in a proper court with the proper information and everything else, he's going to lose all his stuff. He's going to lose his job. He will be disbarred as a judge, and he will lose all his assets, and you will get them all. So you'll get his house, and you'll be able to sell it. because he loses all his assets.
Wow.
Because isn't that what happens to everybody in English law when you break the law? They come after your assets. Right? Because that's the agreement that you made. You're going to grant them these things, that right over those things, so when you do something wrong, that's what they're going to come do to you. But that wrong
like
is
the
what
waste
the group
for the
decides.
wrong they've done to you.
Pardon me?
Is that like a waste for a wrong? So they wrong you, and then you go and collect the waste for it.
Yes, when you're as donor, that's correct. They're all. That's why it's a waste, because everything that fee simple are not allowed to cut a tree, dig the ground, or anything. And if they do anything, if they do build a house or anything else, and they don't maintain it, it's another writ of waste on top of that, right? Because they weren't supposed to build it in the beginning. So whatever they build, they have to maintain, and that's why the government is saying, that's why the laws of equity are. You have to maintain it. You have to cut your lawn. Once your house gets so old, you have to update it. And if you don't update it, they're going to take the house from you and sell it to somebody that will. Right? It's just that simple. Like, you're committing waste. Every car, every police car, everything is actually the donors, because they weren't allowed to dig the ground to get the natural resources to build that thing. They don't have any natural resources. They don't have any right to it. That's why they have to pay tax and get a license to have it and everything else.
Okay.
You're saying that the donor had all those rights?
The donor's the only one that has the rights to those things.
Right. So if they take something that was the donor's and they use it, then they wasted it, basically.
That's right, because... Well, the reason why they wasted it, because they're wasting their own inheritance, which is also yours as well. Because got to remember, everybody, just like everybody in your provincial jurisdiction, they're all bound by the same laws and stuff, right? You see what I'm getting at? So when somebody takes advantage of the system that you're in, they're hurting everybody inside it. So, because you're giving up my natural resources and your natural resources to somebody else for no benefit to yourself, to rape and murder my planet so they can enslave more people to keep doing the same thing, yeah, you're fucking injuring me, man. You see what I'm getting at? And that's why that's another reason why they kind of don't want this really getting out to that extent, because it's going to turn everything on its head, right? Like, it'll never destroy the system because it can't, right? It's an individual injury to the individual. It's not the government that's doing it. You gave the land, and that's why you can't actually sue the government per se for anything but your corporate release. And you go after the tenant that's holding the lands, because it's the tenant that's actually injuring you from your estate. It's the government that injures you if they don't release your corporate person when you give them a proper notification and do the proper things. So when we look at it that way, the government actually has nothing to do with anything. They're just the company to regulate those within the use for a fee. And because the monarchy created the government, you gave the land tenure to the government, then you volunteered to that government. So you just went and punched yourself in the face. So you can't sue yourself for punching yourself in the face. That's another reason why you can't keep your lands that you currently have and then sue yourself for those lands. Right? You can't decide yourself. You can't fulfill yourself. You can't fulfill yourself. You can't do any of those things to yourself. Right? You can't injure yourself. You can punch yourself in the face, but you can't go to any court to remedy that for yourself. Like, just stop punching yourself in the face. you kind of see what I'm getting at? Like, there's nothing that anybody can remedy if you're taking your natural rights and choosing to punch yourself in the face with them. I can't do anything about that.
But can you heal yourself?
That's right. And you choose to
After
heal
you beat the
yourself.
shit out of
That's
yourself,
right.
can you heal yourself?
That's right. And if you decide not to take care of your wounds and you die from those wounds, you did it to yourself. Right? Like, I can't do anything for you, dude. Like, right? All I can do is say, hey, you better clean that cut. I can see that it's getting infected. But I can't do anything more. I can't hold you down on the ground and clean your cut for you. You kind of see what I'm getting at? Because now we're in natural law. We're not a part of a group where I agreed that I give you that authority that if you think that I'm mistreating myself in any way, you can call the police and get them to come take me away and hold me against my will forever. Right? You kind of see what I'm getting at? Like, I can't give that authority to somebody. I just can't. Right? Like, it just blows my mind how long this has gone on. Right? So.
Well, nobody had the map. You know, the map was here, but nobody knew where it was. It's like the treasure map. It tells you how it works.
Look at the data. Look,
I know.
It's all stated that if we did it to ourselves. I hate to say it. There's the working class has never looked at the law. Never. Not ever. Like even in the times with like the during the times of the faith wars and everything else, even it seems like the only time that people really looked at the laws was at the very beginning from 1066 until like 1285 or 1225 in the last Magna Carta. And it seems like since the monarchy restricted themselves at that time, it's like everybody just forgot about the option of getting out and just wanted the protection of the king, right? So if we look at the era and what was happening at that time, yeah, we can see that, but because we're talking like 1300s to 1300s to like 1500s was like the faith wars and stuff. Right, and then they were booting Christendom right out of the English law, right? And by 1688, it was completely no longer a part of the common law. It was only equitable law, right? Because everybody chose it, so they can't take away something that everybody's choosing. But they can bar you from your trust, right? And that's what they did in Bill of Rights 1688. That's really what truly barred the corporate person from getting their trust. Because you're a part of equity, which is Christendom, which is all fake. Right? Like December 25th is not the birth of Christ. It was the birth of English law when King William was crowned December 25th, 1066. You kind of see what I'm getting at? So when we actually look at how this is all done and how it's been laid out, we can see that it's the releasing is pretty much releasing of the things and the lands, right? So because this gets into the two different areas of law, right? Because lands is the actual land tenure, and then of things, because we got to remember that in equity, property law is not actually about true ownership of the land, right? The real is unmovable things, and personal is the movable things, right? Like vehicles, right? Things that you can just move off the land, right? Like a house is considered an immovable in equitable law, right? Where a mobile home is not, because it's got wheels on it, so as long as it's not fastened to the ground, right? It's considered a personal item, and it's a movable asset, right? So that you can keep that sort of stuff, the movable stuff that you want to keep, those things you go and you can give them to a friend. So once you're out, you just you write him I noticed that, right, that you're taking that stuff, and he'll just give it to him, and then he'll just attach that to his taxes, and they'll remove those things from his taxes, right? Because now he no longer has those assets, right? So it's very simple, and all this stuff is all accounting.
Wait. Go back on that a little bit, because that kind of ran over that quickly. So if you have a car, you have to, if you're going to actually give it away to someone, there has to be a change of title. So what do you mean put on your taxes?
Well, just like when you sell, if you give or sell somebody a car, right? And let's say, because most people do have businesses and run everything through a business to write everything off. I don't think you guys have found that loophole for living in equity yet, but it would be a very good idea for you guys to start right now, especially until you get yourself out. Anyway, so because businesses act as a way to write that asset off and use that asset as an investment, as collateral, and so on and so forth. So if you were to give it to somebody that was doing that with their asset, right? Because as soon as you sell or give that thing away, you've released all your rights to it, and they've taken it on, and that's basically what the bill of sale is for. That's what it's doing. It's removing your rights and duties and actions to those things and giving them to another. You're transferring the deed. Is basically all you're doing. And they gave you the right to do that without having to do a judge or have somebody operating as a function of government. Some things they require the function of government to oversee it. So when you come back and take that thing back, if they've used that thing on their taxes, all they have to do is submit your notes and them signing it over to you in taxes, and that removed from their taxes. All right, so now it's removed. So now it's removed it from their jurisdiction completely, because you've shown that you've released it back and everything else. And immovable things is not, a judge is not required to sign it over, but all immovable things you have to. Like lands,
Hey,
you have a judge to do it.
somebody's in the kitchen
One
or something, making dishes or something.
Who's making a cuppa?
Chris,
Can you put your microphone on mute, please?
It's a couple.
So as you can see, that's why they're splitting that up into two different jurisdictions, especially when we look at the land tenure, because only a judge can give the lands back to the donor, because that's what it says throughout all the history of law, right? Even in Littleton's time, right? Only a queen's judge acting in the capacity of the queen can exempt the lands and do those things. So that's why the release section is also so big, because now we got to throw in all those different types of things too, right? And also in what manner you can release them at, right? And that's going over, like, that's bluntly just like quickly going over, like, right, if you got tools and so on and so forth, right, and a truck and all these other things, you have to give them all back, and he has to touch on all of those things and in which way you can and can't do it, right? So basically what he's saying is you can't go quit your job first and then decide to release all those things that you're holding a part of that afterwards, because that means that you've abandoned your duties to those things, and you're a trustee, and no trustees can abandon their duties to a trust, right? So that's where that comes in, right? Because we're all acting as trustees to a set of KV, right? In our own set of KV.
Discharge.
That's right.
Release.
That's right. And so that's really all this is, and that's why it's so big, right? But you guys have to read it and understand it to be able to go to the next level, right? Because after we go through these sections in commentaries upon Littleton, then we're going to breeze, because this is the deep stuff. All the next stuff after reading the commentary upon Littleton is all the big reading. Once you get into Coke upon Littleton and Blackstone, it's all going to be a short little paragraph, one-pagers most of the time tops, and following a footnote briefly to the same thing, where it's only going to be a paragraph in another book. And then you'll have it traced right to the very end. That's how simple this is. It's overwhelming at the very beginning because of all these things that are pummeling your minds right now. But that kind of has to happen to understand all the different capacities and where all this is going. And because if you don't pummel your mind now, your mind's going to be pummeled in court, and then you're going to fail. Because you have to have a basic understanding of all of these things in order to move forward. So, did you record any of that by any chance, Justin?
I don't think he did. That was great. I was thinking we should have had him turn the recorder back on. I didn't realize I was going to get to.
Should have had that in the question and answer period.
To me, it's so much more understandable now just by you going over this. I've gained like so much out of this, even to know, where to look and everything. It's been fantastic. I'm super happy that you did that. Now we know how to grasp it out, understand it.
And that's kind of the hard part about teaching it, is you've got to give so much more information than what anybody's going to need to go through court. Like, what you have to learn here to understand it and what you're going to actually have to do in court are two hugely different things. I can't stress that enough. Getting this knowledge is 99% of the battle and the hard work. Once you get the understanding on how all these capacities work, how it started, and how it's gone through the different areas, when you're going into court, you're going to find that it's almost nothing, right? Because you're going to have all this information, and you're just going to have to add. You're just going to write your summary, and then all the work's going to be adding all the stuff that you're footnoting and making sure that you're writing out all the things to prove that you have the law, right? What book, what section number, and what page, right? And write out that important piece. If it's just a sentence, just a sentence. If it's a paragraph, right? So the judge can actually go, what you doing? Where are you going? Okay. So, because you got to remember, all these things are going for right. So, because all these things are actually written in your own words and done in your own words in the courtroom. So you have to have the capacity and the knowledge to be able to summarize these things and convey what you're trying to get at, and have the law just there to back it up, if that makes any sense. So right now it's mostly reading, and as you guys find an important paragraph, write that paragraph out, write what book you got it from, what page number it's on, right? So you already have it, right? And keep it categorized the same. Coke upon Littleton, release, remitter, warranty, right? That sort of thing, and keep them in their proper categories and stuff. So when you're at the time of that you've done all your reading now and you're ready to go to court, everything's done. I guarantee you it'll take you an hour to write out your affidavits and your claims. And then the rest of the time, you're just going to be tweaking your wording from it to make sure it looks good and everything else, and making up your supporting document page, which you've already found all the information to, right? And as you're going, because now you know the procedure, right? Where I didn't know all the court procedures, a lot, right? And I wasn't copying everything out that I should be, right? Like in private international law, there's good stuff in there, right? I should have been copying out, right? And so on and so forth. I've been doing it in the last couple of years. That's why I got so much of it. But I would have it, every single morsel if I would have kept proper, like a pen and paper with me all the time, or get your WordPad open, right, and do it all at the same time. Just take your time and go through it properly like that, and organize yourself, so when you come to the end, you don't have to fucking reread all of these books and pages to find that one little paragraph, because you will have read so much and everything else. It's almost impossible to remember what paragraph, in what chapter, and in what book you read all of these different things. So it's kind of important that the things that you, now that you're kind of understanding that you only need the important parts, when you come across those important parts, take them out and get your documentation going. And it'll also help for everybody, because if we all start doing that right now and combining those things, then all the information's for everybody, and then it's easy to, like, for putting it on the website. Once it's typed out, to get it on the website just in the basic form is super fast. Adding a whole bunch of links and a whole bunch of action to this to it and everything else, that it'll take longer to do it. But just the basic, drop it in just basic paragraph form with making just a couple of things bolded or underlined, that's fast, right? But when we're actually trying to design a great big page and stuff, then it's the design that takes the time. It's not, once you've actually got the words done, it's just copy and paste them in, and then put a couple of characters in front and in back, and it's done, right? It's that simple to put things on the website. It's kind of getting the design and everything that you want it to look. If you wanted to click on a word and it'll pop up for a definition and have another article or something, then it gets more stuff. But categorizing for yourself is very important, and it's just going to make your life so much easier for when it's coming time to do it. Because by having a complete affidavit, tracing the law from the very beginning to the very end, and being correct about it all, and showing that you're correct about it all, pretty much stops them dead in their tracks. There's going to be nothing more to discuss. You're not going to have to stand up there and start justifying things that you didn't put in there, where they can actually get it to a footnote. And also, by it being written out to that extent and everything else, if they do challenge something in it, it's already been added into the court documents. It's a part of the case. They cannot deny it, and now you can just flip directly to that and spout it right in there. Now you don't have to be gets flustered or anything else, because you have everything complete. You can be calm and relaxed, knowing that you've traced every era of law to find out how the next one got its authority, and that it doesn't. And what they're doing right now, they're not allowed to do. And that's really all we have to show.
It's more
right?
guiding the court, isn't it, William?
Exactly.
Arguing with
because
it's not an argument anymore. Exactly. We know the law. We're going to show them right. The law, and they're going to be guided by our work, and if that's how you move the court in a proper fashion. There is no argument.
Yeah, by yelling. That's right. There's the law. If you're not going to listen to the law, then that's fine. You can just continue and do whatever you're going to do, and I'm going to file a leave to appeal to the Superior Court right now.
Yeah, and you will pay the consequences then.
That's right. He doesn't even have to listen to that. Even when I was my last court date, because it was in a corporate court, and they wouldn't recognize any common law or anything, and he wouldn't even recognize a leave to appeal to a Superior Court. So you don't fight with the judge; you just let him continue. You see what I'm getting at? Let him do what he's going to do. Just sit there and every chance that you get, deal with that thing in the manner as the donor, and prove that what they're doing is wrong. So once that is over, you can just leave and go and do your writ of error, and you're done. Because now he's even giving you more room by continuing and allowing you to prove more things, because all those people that you're going to be challenging in the courtroom are all ignorant of this, right? Because the judge can't hear it or determine it, so he's forced to injure you right off the hop, right? But everybody else in the courtroom that's trying to force these bills of equity when there is no contract between you, they're being ignorant, and you're just pummeling them and showing and making more evidence for your next case for that error. Does that make sense? So they're actually, by them doing that, and by you not getting angry and just dealing with it properly and getting more proof, is better for you than fighting with them. Fine, if you want me to, that's fine. I'll spend the next 2 hours here asking these guys questions, right? But I'm not going to be asking the questions that you think I'm going to be asking. I'm having my own common law court, right? You can't recognize it or determine it, but the next judge that's going to read all this it can.
I was going to ask how your court of record comes into this. So basically, your court of record is your statement of the law, even whatever they say. Doesn't matter.
No. Remember, law is a contract. There can't be a law unless both parties agree. Right?
So are they agreeing to you having a court of record?
It's always a court of record. People think it's not a court of record, but it is. All trials are a court of record. They're being recorded.
Yeah.
Right?
No, not all cases.
All trials are recorded. Every trial. It has to.
Magistrate isn't. In England.
That's not a trial. But that's not a trial.
Yeah. In what sense?
As in, a magistrate isn't going. A magistrate is not going to be sentencing you to murder. Not anything that's an indictable crime. The trial is of record. It has to be, because you can lose your freedom from it.
Yeah, an injury.
Yeah, but it has to be an indictable offense where you can actually go to jail. So if you get just stopped for 2 grams of pot in your jurisdiction, maximum that you can ever get is a $50 fine or even a $50 million fine, and you can never go to jail, then that's not going to be a court of record. And then a magistrate can deal with that.
A magistrate can give you up to the 12 months, I think.
Then we'd have to look at your jurisdiction to find out how they got granted that and why and for what things, right? Because that's the part of the 3 levels, right? Because the judge is also a part of the case. So you got to remember that you need to know what law he's bound by and what authority he's gotten it from, right? Because the judge is bound by a different law than the defendant and the plaintiff. Than the plaintiff, right? See what I'm getting at? So that's why you have to understand the court's parts too. So we're going to get into that after about the internal jurisdictions, and they change by your province or your state. So in Florida, it's going to be different than here in BC, and in BC, in Canada, it could be different between BC and Alberta. And every province can actually be different for the administration of law. But the law is the same, right? The law is the same, but how they administer it can be different, right? So, and that's the thing. Do you really need, if it wasn't a court of record, by you continuing to do those things, by you writing your affidavit, like if it wasn't, like in your situation, if you're saying that there is no court of record, and this is why it's important to know whether or not it is a court of record or not, is because if it isn't a court of record, you are writing an affidavit in your next, right, 6.An chapter 18 is your affidavit in your own words. So why would you not be adding that in your own affidavit? Either way, whether it is a court of record or not. But you see what I'm getting at, right? It helps to know if it's a court of record, because if you know it was a court of record, you can get that court of record presented to this court that you're in now. You see what I'm getting at? And if it wasn't a court of record, then your affidavit would suffice.
Yeah, your affidavit would make the law.
Yeah. That's right. So, because basically because you got to remember that because a magistrate is also an equity, so they can't hear or determine it either. So they're forced to injure you right off the hop, right? And that's why getting into the court stuff, whenever you're in equity and they pick you up and you're in a bail hearing, never challenge jurisdiction, because you're going right back into jail until your trial date comes. Right? Like, they can't hear or determine common law. Don't bring it up. Right? The only thing that they can deal with at a bail hearing is if you're an injury to public and if you're going to show up to discuss this. Because jurisdiction is not you even showing up. Right? We already know what jurisdiction is. Jurisdiction is who you grant the lands to and what contracts you agree to. So because you don't have your lands back, they have subject matter jurisdiction over you till you get your lands back. If you've released your corporate rights and duties and the government's just being a cock and not listening and they're still trying to give you bills of equity, then that's an injury you have to take to the Queen's Bench. So, and in order to take it to the Queen's Bench, you have to be out of jail. So you can't challenge that at that point because that judge, equitable judge, can only do what his law says, right? Remember, everybody's bound by their own laws. So he's in equity. So he can't do those things. So by you challenging jurisdiction in a bail hearing is the wrong way to go. Because you can accept all those conditions that they make and directly go to the Queen's Bench because they've forced you, because they've incarcerated you. Now they're forcing you to do those things because what they're saying is you have to abide by this or we're keeping you in jail. Well, they don't even have a contract. So you better agree to those things, get your ass out of jail and go to the Queen's Bench and prohibit them and make a claim, right? Get an injunction, right? Get an injunction, right? Because as soon as you file a claim, you can file an affidavit for an injunction at the exact same time, right? And then you should be filing your notice to admit at the exact same time. Right? Notice all those documents that you sent them, right? And everything else. Same with notifications to that corporate judge if you want to send them something before court, right? So he knows what's happening. That also gets put in there, right? Showing that they've actually injured you, right? But you have to be in the Queen's Bench to do all this stuff. You cannot be in a corporate court. And that's why everybody keeps going to jail and everything else, right? And that's why when Dean Clifford got sentenced in the Queen's Bench judge, he rattled off and fucking ripped him a new asshole for 20 minutes for wasting their time. Because now that he was in Queen's Bench, he moved himself out of equity into Queen's Bench to vest his estate, and then he claimed equity again. So that's why he lost. He was standing pat in equity and forced equity to recognize him in common law. So they gave him that, and then he blew it. He went right back into fee simple. So that's why he got 3 years. You see what I'm getting at? And it's because people aren't understanding jurisdictions or even the law. They want to come. They think that fee simple, that all these fee simple laws, when they're talking about, oh, you got absolute ownership, that's not what that means. It's something completely different, and we realize that when we go back to the Littleton and trace it from the very beginning till today. So that's why the release is very important, and it's very simple. It really is, because if we look into the manner that it's done, because that was the matter, right? So the matter is about the things, right? The manner is how you do it, how it's actually accomplished. So we can see the manner of making it, and if we go here, the persons to whom a release of right of land may be made either to the tenant, right, of the freehold, or in possession, or in reversion. In reversion, sometimes as if deciser makes a lease for life, but no one but not to one in remainder. In right. See? In drut. Drut means in right. So this means the true owner. Right? And such a release shall benefit the particular tenant if he have the deed to show. Right? So basically what he's saying there is, if you can show that there's a deed, when we, because the government grants a license to you, volunteered to the license to the government to get a license for something that you gave the monarchy for no benefit to yourself. How to say that? Land titles, well, not land titles, the law gives the right to the fee simple tenant that loses their land to one in reversion or remainder. He can set off that entire value of the property and the waste to the government, so the government has to pay him back. So that's where that part comes in, where if he has the deed to show, right, and that's where et a conversial comes into play, because that's what that's meaning. It means that there's a warranty for both. There's a warranty for the donor, and there's a warranty for the fee simple for if the donor comes back and takes the asset back that you're holding in trust, you get the money back for it, right? As long as you do certain things and you understand and you know the law. Because remember, English law, if you don't know that you've been injured, and if you don't know that there's a remedy, and if you don't go and get it, it doesn't happen. So all those things have to happen for you to get a remedy in English law, right? So that's very important to always keep in your head, that you have to have all those three in order for you to go to the courts to get a remedy, right? So, and then if we look here, and by the manner, by descent without actual, right? Because this is by deed, right? And then by law comes by deed and by law. So basically, if you notice that they split this exactly the same, and it's the exact same page, what is a deed? It is the law, right? An indenture, anything that's signed, right? You've agreed to it, it's law. So it's pretty much the same. And then this goes back to descent of titles, because you got to remember that your very first ancestor that joined the English law is the one that granted the very first lands, and every child in every generation since then has assumed that's those same corporate rights from your original ancestor that granted these lands. And that's where that corporate person comes in, where the law will stay the same generation after generation, as long as the group doesn't change its laws. All right. So if the jurisdiction doesn't change, right. So we now know that there's been at least 3 land tenure jurisdiction changes. So there's been 3 completely different, newly written laws in place. Right. So the descent works both ways, right? Because you can descend in title at any time, and you can descend anything else as well, right? In your releases and so on and so forth. So descent is also, almost all this stuff works in 2 ways, whether you're in fee simple or in the natural capacity as a donor. So that's why it gets so complicated with this release section. And the things that really stick out is when it talks about the reversion and remainder. Like if we go to like here, it says, well, we should start here, because it starts off by ancient remainder, right? So that's the warranty, the fee simple absolute, right? The simple absolute, the warranty, because we can never be disinherited from our lands. They can never take them away from us, and that's why they made the corporate person, because a corporate person does not can never own anything. So they can never disinherit themselves. They can only disinherit themselves. They can never disinherit anybody else because they're a corporate person and they can't take ownership of anything. So the only way that they can get out of that is by the ancient title, because you got to remember all this was created in 1060. Well, by 1085, I think it was the Doomsday Book. And by the Statute of Westminster the First was enacted the feudal law, the feudal land tenure, right? The Mortimer started the ancient land tenure system, which is just after that. So as you can see, the law always it takes a long time for the English law to catch up in the new jurisdiction. So it's always unlawful and illegal for every new one of these jurisdictions that first comes into place, because there is no laws for the government to be doing those things to the people. Right? And that'll really come into play when we start talking about municipal law, because we did a lot of that during the creation of that. And it's even talked about in excess.
Hey, William, I wanted to ask you something about that. When you are suing these people, you're basically suing the Register General or something. And I was wondering, since they don't have the right to hold these lands, why are we suing a fee simple position, something that we have a lawful right to?
Okay, but are we actually suing the government? No. We're not. The writ of entry is against the one that's holding the lands. So it's whoever holding the lands. If you're claiming a provincial park, then the provincial government's holding those lands, right? The government only has anything to do with it if they're holding your lands, and they only have it and to deal with the corporate person, the release of the corporate person. That's it. That's the only thing that we deal with government about, is just the corporate person. We have to name the government with the tenant because the government gave them the license to do this to the property, and they're the ones that collect the fee for it.
So when you sue someone, you're suing the person who's holding the land that you're claiming?
That's right. That's the only one that injures you. For the land, right? The government can only injure you by not releasing you and forcing you to be a corporate person. Right? Because they can't, and that's why you also give them the choice to escheat the lands back to the donor. With your discussions with the government, because they have that choice as well. They can just take those lands back from those people if they want to keep the trust secret. But it seems like they want us to be doing this to people, because it seems like with everything that's been happening within the last 5 years, with the monarchy saying King William's going to be the last monarch, and so on and so forth, it seems like we're on a razor blade. Whether the world is going to go back to a world of natural donors, or it's going to fall into another 600 years of corporate fiction bullshit. Because if people don't get this now, as soon as they make this new system, they're never going to get it. They're never going to put the link. But just by the English law making these different land tenure systems and making them complete individual and new jurisdictions to themselves, where they have to make new laws that are created from the previous one, makes it so people won't look at the previous one to see what authority they even got to make those laws. And when we go to the very beginning, we look at, they don't have any authority at all. They write all this shit like they do, so it confuses everybody to shit, so they don't understand anything. Because not many people are going to take the time to go through it and, right, every era and check between them and everything else. Like, how many people do you know are going to take 10 years out of their life because they can't work or anything when you're doing it.
I know what.
Because it just takes too much time.
I know what.
Yeah. But that's what I'm kind of getting. Like, you can't have a family. You can't, like, if I had, the only reason why I was able to put this amount of time in was because, for one, the government came after me so bad, right, and made it so I couldn't do anything else, and I don't have kids, right, because they always come after everybody's kids too. You kind of see what I'm getting at? Like, when people start pushing the government, they fucking come after you any which way, shape, or form possible. Right? So we know how wrong they really are, right? And why they're right. So by you going and being vexatious and frivolous to that extent, and you're completely against the law to that extent, when we're looking at it in that fashion, you are making yourself unfit to even have children, because you're going and making a stink to that, right? And you're just making another generation of fucked up people. Right? Instead of just going and learning the truth and having the truth. Right? So when we're looking at the whole of law, natural law, and all of it together and all that and putting it together, that's what that means when we're actually doing these things and doing them in such a crazy manner, because everybody in fee simple can't own anything, but yet people are punching each other out and everything else for a fucking TV on Boxing Day. Like, if that doesn't, right, they don't own it. They're not, it was unlawful for them to create it. And it's all an injury to themselves. But yet they're going to go and injure another individual when they don't even own that thing. Like, this is like it's almost like we're going backwards. Like, it's almost like we've gone past the Bronze Age and we're back in the Stone Age. Like, literally the Stone Age, breaking rocks and trying to figure things out. Like, it's that bad, right? Because in English law even states that. It's like, there's no reason for anybody in English law to be taking up arms over anything, right? Over any of the things whatsoever, because there's a law to take care of all that. And that's why law was created. So we stop these violence and everything else. And then that's why we have all these wars and everything else, because all these fee simple are just going around forcing all these other territories into the English law. And we're allowing it to happen because we're so ignorant that we don't understand the law. So, yeah, when we really start looking at it and at the true foundation of what English law really is, 99% of the people are so wrong about it, it's not even funny. And that's why we're going down the road that we're going. So this chart really makes it.
Still online? Justin's still here?
Just about.
Okay. Well, you weren't recording any of that, I guess.
I had a separate audio being recorded as well, yeah. But for the screen share, I just got the first 8 minutes when we're done the release.
Awesome. So your sound recorder can just go indefinitely, right?
Yeah, my sound, that's the one I paid for, yeah.
Yeah. No, that's good there, because we only needed the video for that first one, yeah. No, because we had some good conversation there. We were wondering if it was recorded or not. Because we don't really need to do a screen share for this, because I can put the chart up.
The screen share has been helping a lot, though, just to see what you're talking about. I mean, it really puts it all together. It's really good.
And then if we look at the other side, we look at what the effect of the release is, the actual effect, right? And so basically how to unearth it, right? So if it's between actual parties or against strangers, right? And it's very important to step back and look at these when you're actually looking at these charts and who they're actually speaking of. Because if you look at the parties between the releases, Miter le Estate and Miter le Droit. Now, these definitions, they're writing this in there because because they can't use the proper words because it's going to be like fireworks going off in your head. So this is who has true ownership, right? As between decisor and decisee. Remember when I showed you that law of uses and trust, and especially even better yet, that piece about Coke upon Littleton, right? Maybe I'll bring that up for you guys real fast. I won't put that. I won't scan through everything with that. See, as you can see, I got a lot of it already done. It's just all over the place.
How do you pull that up so fast? You just do it by memory, or are you going by the page number, or you had it alphabetized?
Because he wrote it.
Yeah, I guess so.
Yeah, well, not only because I've read it a lot, and yeah, I've, like, as Justin was saying earlier, the more you guys talk with people, and even like, this is where Facebook really helped me, because all the haters and everything, there's nothing better than a hater. Take pride in those people. Use those people to help you not get angry, because this is going to help in court. Because the government acts the same way. So when you can deal with people on Facebook where they can't get underneath your skin and you can prove them with fact, right? Like you can just say, hey, you're wrong, read this, boom, and then drop the source link with it, right? And the more that they go on, and the more that you can paste and prove your point and everything else, and all, like, you know what I mean, and all the information to it, it's helping you more than you will actually realize now. Facebook is really what helped me learn all this stuff, so I can just jump right to it and bang, right? And because that's where I got it, because like, I've been doing this for a long time, and you guys are pretty much the first ones that have gotten serious about even looking into this and even reading it. So it's been a long time of me showing this to people in an excessive way, and it's helped me, and that's really what has helped me the most, because they bring up such crazy, ridiculous things that if you can prove every ridiculous thing by fact that these people are challenging you with, when you comes to court's gonna be like so easy, it's not even funny, because you're not gonna have to deal with people thinking afterbirth has anything to do with law, because afterbirth is, you can only have a trust once after you've been born, right? It's not saying afterbirth as in like if you look in the equity law about registrations of birth, they talk about afterbirth and shit in there, right? Well, they think that means that's what jurisdiction is, and so on and so forth, right? And when you can show those people and all these different people that are so drastically wrong, and you can prove all of them wrong, and in a way like that, it makes it so it's just so much easier for you to wrap all your head around this stuff. So I'd like to point out like this section here, because Koch puts this extremely well, because it's what is a lawful or the pure inheritance, right? And it's very important that, because this is in the disjunctive lawful, right, or pure sense, right? So that's a very important. Also, not real law, it's only real law for this jurisdiction. And that's what, right? Disjunctive, right?
Yeah, that's called
So
a bylaw, huh?
Exactly. So that's what this is. So for every fee simple is not actually lawful, right? A decisor, a baiter, intruder, or a usurper have a fee simple either by purchase or descent, right? So that's a right. So these guys have a right granted by law, right? So if we look at, go back to this, where was that sucker? Oh, decisor, here we go. Mitre le droit, as between decisor and decisee. So if we look at what the decisor is, shit, I don't have my Facebook thing up. I'm going to have to bring this up real quick. Because it's important, very important, because it's determining, because the fee simple is by right, because no one is challenging it. Just give me a second here, guys. Okay, is the sound back and everything? You guys can hear me okay?
Yeah.
Okay, so as we can see, the decisee is the one who is wrongfully put out of possession of his land, the one who is decised, right? The decisor is one who puts another out of the possession of his lands wrongfully, right? So this is telling you that there's an injury because it's wrongfully done. All right. Same with this one. The one who is wrongfully put out of possession is one who is decised, right? But this is the decisor is the one who's doing it, right? The decisee is the one who it's happening to.
Right.
So if we go back to this, so we know that purchase and right decisor. Notice that it is decisor here, right? So decisor is the one which what? It's an injury, but it's not actually a total injury yet, right? Because the decisee, right? Because it's only put out of his lands wrongfully, right? So it means that somebody is injured. But remember, English law, there's no injury unless you complain about it and can prove it. Okay, so when we look at this, we look at it as a decisor, right? So it's saying decisor here. So there isn't actually any injury yet because no one's made a claim to do it, right? So they have a title by fee simple, right, of purchase or descent, right? So either you purchased it, so you went and got a mortgage, or you just went and bought it, right? Or you got it granted by your parents that are in fee simple, right? Because everybody in Canada is in fee simple and they have a title by purchase, right? So then we look at the wrong side, right? It's decision now, intrusion, abatement, and usurpation. So when we look at, see, even the next ones they'll even help us here, because a baiter is another form of an injury, an intruder is another form of an injury, and the usurper is another form of injury. But all of these, there's no one making a complaint yet, right? So there is no actual injury, right? So it's not lawful, but this is legal. But only legal for those in fee simple. These are the only ones that have agreed to those rules. right? So by wrong is by decision. Means this is now where I want this. I want that back. And they're not going to give it back. See, so the determining factors between this and this is somebody choosing that they want it back, that has the right to choose it back. Fee simple does not have that right. Right? So you have to, the only ones that have this right, the only way that it becomes wrong is if you're no longer the corporate person and you're standing as a remainder man being seized of your lands and your inheritance. Right? So that's where this gets really interesting.
In
right?
In equity, I guess they call that being the executor or being the executor de sunt tort. If you're the executor de sunt tort, you're the executor in the wrong. In other words, you took
That's
executive control over it, but it's wrongful.
That's right. Because you've got to remember in fee simple that this doesn't apply in fee simple, so that won't be in that law because everybody in fee simple has agreed to those rules the way they are. Right?
Right.
Because it's a system inside a system. That's why that chart would be really good, like to make a graph chart right off the hop, showing that the trust starting at you as the donor, and the monarchy is actually the trustee. And the government.
You mean the synopsis one?
Yeah, the very first line. That's right, yeah. With the blue things on it, because that really will show when it's all color coordinated and everything, and on a way down. Right? Because then these releases can follow right underneath it and keep showing the same color patterns, right? And same with confirmation and all the other things that apply. And then same thing in the case law and everything else. We can just be highlighting in that same color, right, for the common law important stuff. Can I see what I'm getting at? So everything is all color formatted so everybody understands what area of law they're reading when they're actually reading it to define it better. So when we actually if we look at this here, we can see that the parties between the how to unearth it between the parties. You can see that there's only two different type of parties here. Those in fee simple and those that have the true right, right? And then it gets into extinguishment, and then as this is where to he to whom the release is made cannot have the thing released as between the Lord and tenant for services. See, because now they're pointing out that because the government, because here I got to bring one more up because this is another important one.
Still?
Yes. It won't be much longer. Right here. I'll make this a little bit bigger. Body politics, government, are not capable of use of trust because they are bodies framed at the will of the king, and no further capable than he wills them. Right? So that's the law, right? And and to his will that they should purchase for the common benefit, because they're also in fee simple. Right, so they have to purchase through the waste that the fee simple create, because the government can't even create waste. Right, you have to go do it for them to tax it to make the money, to benefit to buy things from you, right, to make more waste, and for the end of their corporate and for the ends of their creation, and that's important as well, right? Because that will once we get farther into, I don't want to get into that right now, but that will more come in. You'll actually understand that further on as we go. And not that they should take anything in trust for others. Right? So they're not even acting as trust, and that's why I'm saying the lands have nothing to do with them, except for the fact that they granted it away to somebody else when they didn't have that right. Right? See what I'm getting at? Because they can only grant the equitable use. They didn't grant ownership of anything. They can't. Right? And also being incorporate, right? And this is where the corporeal and or incorporeal tenements and hereditaments come from, right? Because incorporate is always only a use of things, and it's always for the government body, the body politic. The chancery, and also the chancery, which chancery is equity, right? Taking your chance, right? You also like the game of chance and also Monopoly, has no process on the person to compel them to discharge their trust, right? Because equity cannot see or hear or determine common law. The king cannot be seized to a use because there is no means to compel him to perform. Now remember, this was in the ancient land tenure time. Now this has changed. Now there's laws to compel them. For the chancery, right? Because he's also trying to, and it's also combining that he's still talking about the chancery as well in that same sentence. Because the chancery can't compel the king. The king compels the chancery, not the other way around. For the chancery has only a delegated power from the king over the consciences of his subjects, right? Because you're basically acting as a robot because you can only do what he says and the things that he allows you to do. And the king, who is universal judge of property, ought to be perfectly indifferent and right to take upon his particular defense of any man's estate as trustee. So you as donor grants to the monarchy. The monarchy created a corporation. We go and volunteer to the corporation to give acceptance to the land tenure. Because when you were born, you didn't sign the live record of birth. There is no actual contract that you go in and sign to grant this over. So they made it so titles by purchase is your acceptance. That's the livery, and it's called livery by cession because you're working as the corporate person, so you're taking lands by purchase and agreeing to being seized of lands. So that's where cession comes in, accepting being seized of your lands for this land tenure agreement. Then if we go into this last section, decisor, abater, or intruder cannot be seized of any use. See? Again, decisor. That's because they've got it by license. And they can't be seized of it, for they take it under no trust, but defeat the estate to which the trust was subjoined. So that's you, right, disinheriting yourself. Right? The chancery has no power to try the right of inheritance between them. Right? So chancery, you can't go to any chancery court to try the title, right? Because that's fee simple or barred from any of these actions, right? For the right of title is triable only at common law, right? In the Queen's Bench, Queen's Court. Or if he who has a use exhibits a bill against the fulfiee to a use, the chancery will order him to try the title with the decisor. Right, with the decisor now, right? Now it's changed to decisor, right? Right, at common law. Right, so the bill is the claim. Right, the fulfiee is the one who receives the fee. And remember, this is where the EE and OR comes in, right? The one that grants it is always the OR, and the one that accepts it is the EE, right? See, because we have to pay our taxes to the government for the use of that thing, that title that we got a title of purchase for, that, right? They tax and everything else. So that's for the fulfiee. Then fulfior. Am I breaking up at all or anything?
Yeah, a little bit. Not bad.
Okay, and then we see the fulfior, because now it should be good now. The fulfier is the person making a fulfillment, or fulfilling another, right? So now we got to look at what fulfillment is, right? So if you look at fulfillment, and this was kind of, the video was posted in the group earlier. Yes, please. Fulfillment is a gift of any corporal. Remember, corporal? Because what's the corporal? Remember? Incorporeal and corporal. Corporal is to the government, and incorporeal is to the government, and corporeal is to the queen, right? Operating as a transmulation of possession and requiring an essential to its completion to the session being passed, right? Which might be accomplished either by investiture, indenture, or by livery by session. See, because we grant this at birth, it's both. Because they have to give an indenture, because we can't grant something at birth. Our parents did, right? And it was accepted. An unlawful contract was accepted by the government because somebody granted away rights of somebody that they didn't have right. Because you got to remember, your parents were into fee simple before you were born. You were born a natural individual. Your parents did not have that right, even in natural law, to grant you over to something else like that. You kind of see what I'm getting at? So when we're actually looking at
than what you've got.
What's that?
You can't give like more than what you have. You can't give a higher thing than what you have. So what you're saying, where they've granted you over and they didn't have the rights to, if they're fee simple, and they're granting over a natural something that's higher.
That's right. They can never own anything, so they didn't even own you as a child, so they couldn't even give you to the government.
Yeah.
You see how English law has more holes in it than Swiss cheese if we actually get to the bottom of the foundation of law, right? This equity is so full of holes, it's not even funny. They have no right whatsoever, and that's why they're giving so many exemptions to these guys that are going into the courts and standing pat, right? Because there's nothing else they can really do. The individual isn't giving them a law that the judge can actually do, so they're just doing what they can where they can until the people actually figure out that all they have to do is go in there and ask the proper things. Does that make sense?
Yeah, it does, and that's why I was wondering why, like you said, when we find out who we're really asking for or asking this of, they're just because they got their power from the government or from the monarchy. I mean, the monarchy created the government, and the government creates the courts. And so the reason we have to go to a court is because they're the ones who have the authority given to them by the monarchy to settle these problems.
Exactly, yeah. And then if we look at this a little bit farther, it even goes back in, right? Also the deed or I'm pretty sure that's supposed to say deed, not deal. Because Black's Online Dictionary has a lot of mistakes. Also, the deed or conveyance by which such corporal, right, hereditamент is passed, a fulfillment originally meant the grant of a feud or a fee, that is a baron or knight's fee. All right, and this is taking us right into Coke upon Littleton right now. Right? And why this is so important.
Starting to get bad connection now.
Hang on there, William.
Why don't we just wrap this up for now and we can get back to it? He can't even hear us.
All these
He's still going.
pieces.
He's on a lag.
Hey, William.
Hey.
I've got full bars, mate, so full signal. William, you lost signal there.
Yeah, I can hear you guys.
You was doing your robot performance.
Yeah, sorry about that.
What language do you speak?
Nanu.
Yeah. More convincing, eh? Yeah, I'm pretty old. At least somebody else does more community. I don't feel too bad. You guys caught this part about a fulfillment originally meant that the grantor of a feud, right?
Yes.
Or a fee.
That's right.
Right?
When you go out.
So it's important, and if we keep on looking at this, it keeps going into the rights, right, of a free inheritance to a man and his heirs, right, referring to the perpetuity of the estate, then to the feudal tenure. The perpetual estate is the corporate person, the perpetual, right, because perpetuity in law can only happen with a corporate person, where, right, and that's how your parents sign you into the feud. You kind of see what I'm getting at? So that's where all this is coming from. So library by session is still being performed today. It's just being performed in a different fashion, right? And when you start defining these terms with the real terms of Littleton, especially in a courtroom, you get noticed. It changes everything, because now we're using the proper words that take it to the proper meaning than what the equitable definitions mean. Just like freeman in municipal jurisdiction means that you accept the feud, right? And that's it. That's in the treatise on treatise on the Municipal Corporations Act. It's also on omnipotence in the books. It's very powerful, and it even goes in about being decised, and that's where you get the proof for your writ of entry, because as we were stating, because the writ of entry is proving that you're deforced, right? That you're out of the ownership and possession and the fee, right? Because you don't get the fee when somebody's taking your land from you, right? Or that thing from you. They're getting the fee when they're not supposed to be getting the fee. So that's also a part of that. So being deforced is right? And that's why I'm actually camping right now, and camping within an hour of the lands that I've claimed, because it's proving that I'm deforced, that I'm not holding lands, I'm not holding anything, and I'm standing here, right, being out of the property when my guardian is holding it for me, and he's supposed to be giving it to me, right? So that's where all of this comes in, both the releases and really understanding the release. Oh,
How come you call? Excuse me.
I got a broken code on there. Okay, I'm sorry. Go ahead.
How come you call the guy who's holding your property, which is just some other guy, right, that has that property? How come you call him the guardian?
Because he's in fee simple, and everybody in fee simple is the guardians to the donors' natural rights and lands, and that's why they have to give these things back, because they agreed to join the group to join this land tenure law, because this feudal land tenure is the contract. All law is built off of it. So we all agreed that if we're going to give our lands to the monarchy for protection and everything else, then we've descended in title, and we're guardians to everyone in their natural capacity, because when we want them back, we want to be superior to the king, because he has no right to keep them. Right? So everybody in fee simple have to agree so they don't disinherit themselves. And that's also why they brought in the corporation. Right? So the corporation is not a bad thing. It was a way to correct the tyranny from 1066. Right? From this feudal land tenure. The modern land tenure has given us the right to take back our estate in an easy fashion. And you could always take it back, but before 1600s, all the court cases were done in Latin. Everything was done in Latin. You didn't even understand anything, including the judgment. From my understanding, if one of us were in court and we were an English-speaking person and didn't understand Latin, we wouldn't know if we got time or not until they came and put the shackles on and leaded you out of the courtroom. courtroom. You kind of see what I'm getting at? Like, it was that hidden. And that's why all these law books, they've been revised. Like Coke upon Littleton, the entire Littleton is written in Latin. All these books have been written in Latin. All these revised is even Coke upon Littleton. And that's why, like, the only way we're going to get the true just and know the real truth to this is if we find somebody that actually can read ancient Latin and translate it perfect.
Anyone?
Anyone that can, right? And that's the only way, because we're basically taking the little Coke and Blackstone and all these guys that they've read this properly and that they've defined it properly. And you'll notice that when you're reading, especially Coke upon Littleton, because that's the really powerful book, and that would be the one that we'd want to find of Littleton's writing and get it translated, because it's the smallest book and the most powerful. And you'll notice that the really powerful sections about reversion, they're not even there. They're not even letting us get to the most powerful laws for this. The laws that I'm showing you now are the easy to find stuff. There's stuff that are still in statutes that are going to be extremely powerful, that like Justin's probably going to have to get in the UK, where he can actually go down to the Great Library, the ancient Great Library in the UK, to actually get this information. Because even some of these statutes, you can't get them unless you actually go to a law library and get them, because even Roughhead statutes, he doesn't translate that one statute. And in Coke upon Littleton, that exact area quoted to that statute, Coke doesn't translate that Latin section of Littleton. You see what I'm getting at? So they're hiding a lot of stuff yet that we haven't even gotten to, that I don't think we ever will, because we don't need to. What we already have already destroys I shouldn't say destroys their system, but it gives us the out that we require without even having to go to that. Right? Because I think if they showed that could destroy their system. So I don't know if we should even bother going to that extent, because I'm not interested in destroying anybody else's system. That's a breach of natural law. If they want to live in that fantasy world, go right ahead. You can keep doing that, as long as you're not going to infringe me of my natural rights and duties. So that's
William,
really where it boils.
Wasn't this stuff supposed to be done by parole evidence anyway the whole time? I mean, you're supposed to be able to just go in and not have any paperwork, just go in and, I mean, you have to have it in your head, I guess, what it's right, but wasn't this a situation where you could just go in and say, hey, I'd like to, claim my land back and blah, 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 and I'm this and that, and that would be it? Because the voice supposedly overrides all papers and everything else. Of course, I know what you're saying, but...
Well, yes, in natural law, yes. But for some reason, right here, I think this is where I think you kind of got it from. I don't think I grabbed that.
By parole, there it is right there. It says number 604. Decisee taking any estate from decisor by parole or deed poll remitted. Yeah,
okay.
Parole
Can you guys hear me still good?
Yeah.
Okay. I'm going to have to reread that part about the parole part more extensively on that page, or even go into the back of the Littleton and the word index and find the definition that for common law for parole. But if we look a little bit deeper into this, but where he has a right of entry and takes an estate, he by his entry is remitted because his entry is lawful. right? And if the decisor and of the decisee and others, the decisee is remitted to the whole, for his entry is lawful. So this is where we're getting into right now, right? Is remitted to the whole, for his entry is otherwise, right? For his entry is lawful. Otherwise, if his entry were away by descent cast upon or otherwise, right? So he doesn't have. So basically, the way that I'm getting this is because
He has to walk onto the land.
well, this is kind of twofold because it's kind of touchy, this part. Because what this is saying is you can actually go and take the lands back. But there's another statute that you also have to be that you have to actually understand, that because you're in fee simple, you cannot just, even if you're in remainder or reversion, you cannot just go and take the lands back. You have to make a claim. Only if the Queen's courts do not do what's required. So if, let's say, you go to the Queen's courts and they don't do it, then you appeal it and they don't do it, then you can go take it. And they can never come and arrest you or anything. And you can do it by force. But you can't do that until you prove that they are not following the law, because there is no law then, right? See what I'm getting at? And that's why I don't think that will ever happen to anybody, because everything that I can find, the judges follow the English law as long as you're correct. It's when you're not correct. So my honest belief is no one will ever have that happen. If it does happen to them, they were wrong in some ways. So if they go and take lands, they're going to go to jail for it because they missed some step, right? They assumed some part of this, right? Where they didn't do something correct.
Yeah, this is the adverse possession type stuff that they're doing.
Well, it's all adverse possession in fee simple because no one's true owner, right? And that's why they took away squatting on land, because it doesn't matter. You're still in fee simple. You'll never have ownership of the land, even if you, right? Like you can't disinherit. So that's why they took away squatting, because they made everybody go to purchase. Now everybody has to purchase, right? Like in BC here, there's people that are living like there's what's called rec sites, and they're like a rustic area where the government went and put picnic tables and fire pits and outhouses. They don't charge. It's free to stay there. Most of them are free year round. So you can go and camp there year round for free, right? And the law in Canada is you can only stay at one campsite for 2 weeks at a time. So you can either stay there till conservation comes and notices you and asks you to move, and then you just move to the next campsite over, right? But what's happening here in BC, because this is the warmest place in Canada, there's a lot of people here doing this. It looks like. Like Cheryl was just doing laundry at the laundromat yesterday, and a guy was living up in the mountains, and he just came down for the next month or two, just for the cold period, and then he's going back up, and he lives literally inside a cave with a tent, right? And there was another rec site, and then there was a rec site where a guy went and got like an outfitter's tent, and where he could put like a wood stove and stuff in it and cook and everything in it, right? And he's already set up and living right where it's actually a lot colder than it is here. And we can start doing this and things like that, right? To have a free way to stay while we're kind of doing our thing. But it's also going into another thing that they don't allow squatting. But here in BC, they're not hassling the people by going and staying in the bush on Crown land and in these rec sites, as long as we're not destroying everything, and right, as long as you're taking care of nature and everything. Everything that I've been hearing and seeing, people are not having issues in this jurisdiction for those things, right? So they won't. they abolished squatting on land because that was but when they created fee simple, they gave everybody the belief that they were going to have absolute ownership, and that's what's kicking them in the ass right now in the courts, because now they have no way to actually start telling people, no, you don't have absolute ownership, right? This is the way the system is. They can't do that, right? Because freedom happened, so now the law is your choice to have to learn it, right? So if you don't take the time to learn it, you're not gonna. They're not gonna tell you, right? You have to go and ask people, or right? You have to take the steps to learn what you need to learn for what you need to learn, and that's not only law; it's everything in life, right? They're just forcing you to learn the basics, right? And that's it. And they shouldn't be forcing you to do that. You should be wanting to go and learn the basics, but you shouldn't be going to a government corporate school to get it, right? Because you got to remember, they can only teach you what the law says they can teach you, so they can't give you a full education for what you could give yourself or your children, right?
Yeah.
They can only give them half of it. So you should be sending them to that corporate school and then teaching them what they need to know when they get home to counteract a lot of the bullshit, but so they can actually start learning it and getting their head bouncing between the two now while they're young, so all these things are not hard for them to understand when they get older, right? Because they'll start seeing the two right away. And I honestly believe that's why they made it till 7 years old, right? Like after 7 years, right, you're gone to sea. And I think that's why, because if we were living in our natural capacity in a proper way, by the time our children were 7 years old, they'd already know this.
Yeah.
Right? Because it's very basic. Don't give your lands to anybody. And when you do that, that means you're giving up rights. And that means that you put that agreement between you and your natural rights. And now when that needs to be done, you have to go do that because you made that agreement. Right? Like, you got to remember that our ancestors used to do things by word. Our word was our bond. Now everything has to be written. Right, and it's because nobody's word is their bond anymore. Like, you can get in all kinds of agreements with people, and they'll tell you, yeah, but when it comes down to it, it doesn't happen, right? And in English law, every time somebody did that, we have the right to take them to court for a remedy for it, right? You see what I'm getting at? Like, if I said, okay, yeah, I'm going to be here for 6 o'clock for a meeting, and I don't show up, right? And you took your time, the whole day off work, right? And I didn't show up, well, that kind of screwed you up, right? And I injured you, right? So that's why it's so important that we abide by the agreements that we make and everything else, and that we don't make ourselves string too thin, because then we start breaking agreements and injuring people, right? It's not us that's feeling it, it's the ones that we injure. So that's why we have to be putting ourselves more on the other person's, right? Putting yourself in their position instead of your position. Like, yeah, you forgot, but yeah, that's not a big deal to me. But what happens to the other person, right? Well, I don't make any money, and I had to take today off to learn this, right? And that's the only money I make for the month. So now that means, right? You can't, like, just because I don't know that doesn't mean that I can break that agreement, because you shouldn't have to tell me all that stuff to make sure that I abide by my agreement. Right? That actually doesn't even apply. Right? You kind of see what I'm getting at? So when we actually look at how all this stuff really works, and that's why the release also works in the way that it does, right? Because I agreed to do those things. So in order for me to change that, I should be right? Oh shit, something else come up, right? But I can't do this something else because I promised that I'm going to be here to chat. Right? You see what I'm getting at? So the only way I can do that other thing that comes up, even if it's more important, is if I can get a hold of Ez in time, and if me and him can come to an agreement to make it at another time.
Yeah, right? It's an honor system.
But it's more than the honor system. Those are the laws of the nature that equity has taken away from us, right? Because now we've made an agreement between a group of people that now it's okay to do that. Right? Like, look how many people, it's like, you know what I mean? I'll be there to do this with you, and then they don't show or whatever, right? It's more of people not completing what they are not completing the things that are coming out of their mouth, right? Nothing's completed, right? And it seems like it's okay with everything, and that's where our biggest problem is coming from, right? Because as soon as I don't do that, now you're pissed off, even though I don't know how much it hurts you, right? But that's the issue, because I didn't know that was one day that you could only work, right? Now that you kind of see what I'm getting at. So that's why it doesn't affect the people that are on my side of the agreement that it happens to so much. But if we stop assuming that right, and let's say we assume that every individual that we make an agreement with, that it's to that extent, that if we don't go meet with that individual, right, it could be a major change to their life. All right? And when we start looking at every agreement being that way, I think we would stop. I think it would help, and it would stop a lot of the issues that are happening, right? Because even though doesn't mean that severity of a thing every time. But if we assume that it is, then that's going to make sure that we always go and talk to the person, so there is no injury whatsoever. You see what I'm getting at? Because nowadays we assume that it's no big deal that I don't go meet them for coffee, right? But it could be because you have something drastic to speak to me about.
Yeah.
Right?
Could I pop in here for a second? Chris, since he was talking about that, the next time we have calls, and Justin too, but the next time we have calls, is this a good time for you to have a call at 9 o'clock at night, or is it better earlier, or what would be a good time if we had like a kind of like a weekly or bi-weekly call at a certain time?
Yeah, 9's good for me.
Okay. I know it gets to be about 12 if we try to keep our calls about 2 hours, then it makes it like 11 o'clock for you or something. And is that okay for you, William, 1 o'clock? Because it's kind of in the middle of the day. I knew that, but I don't know if
that's okay for me. It's more to make sure the guy, like Justin and all the time zones work together. That's kind of what I'm working on.
Well, that's why, since we have like 8 hours or 7 or 8 hours in between, I was trying to kind of do it where we could both work out. But I think we should, keep the calls about 2 hours, because if we want to re-listen to them, we can, if we know what's going on. And then next time, maybe we can talk more about the release. But I think today was like super productive as far as, looking at the charts and kind of understanding how the flow and everything. As a newer person, I guess it was really helpful for me. I hope it was helpful for everybody else, because I'm sorry about my computer getting all messed up at the front. But I think it was really good, but we didn't really totally get into the release because of that. Maybe have another call back next time.
But one thing that I wanted to point out is how English law writes it, where if there is somebody complaining for an injury and where there is no one complaining for an injury. Mm-hmm. Right? Because we got to remember, fee simple is based on they're holding something until somebody returns. So because they're holding it as a use for a fee, it's not actually an injury yet until the one that comes back that actually is the true owner, and that individual doesn't give it back with the proper notice. Right? So that's why the releases are important, so we know what capacity and how we can release things and in which fashion, right? So you as fee simple, you can only release your lands if you're holding lands. You see what I'm getting at? You can't release lands until you own lands, right? So, like people that are just renting and stuff, you're actually deforced right now as soon as you stop doing those other things, right? So most people just can't live and pay rent and not work and do all those other things. So that's why I was bringing up rec sites and camping and those other things to help that transition period, right? Because even though the law says it happens immediately, it happens in law immediately, but it's us having to go to court and being in that, changing our action before we get to court, because we have to prove to the court that we're no longer that corporate person. So you have to change those things, right, before you can actually even go to the court. So you kind of see what I'm getting at? That's why the releases is really important to really understand it as much as you possibly can. And the charts, we should really work about trying to get these charts from Littleton done in an easier fashion.
Yeah, I'll get working on that because have you guys ever heard of Fiverr? Fiverr is a kind of graphics and different types of programs, and people will do almost anything though if it's $5. That's all it costs, and you can go up and ask them to do just about anything, and they'll do it. And of course, if it takes longer, they're going to charge you more than $5. But it's a pretty cool little thing that work on, and so I could easily, if we could lay this out a little bit and tell them what we're trying to do, we can make an explanation of it. They'll do it for ridiculously cheap amount. So I'll get that all done. So you and I can talk about that later about the colors and stuff. So I've got that understood. But I can get that done, and maybe next week could have all that all done.
Well, just give them one little one to see what it looks like, and we'll work from there, eh?
Okay.
Like
I'll try.
Don't give them a great big release. Yeah, give one that's only going to be $5, so we can, you know what I'm getting at, right? Like, there's no sense
we can get it
out the window.
We can massage it and make it the way we like it, and we can change it a little bit better. Yeah, I get it. Okay.
That's right. Yeah, and then they know exactly what they're going to be doing for every time after too, right? So
yeah. I think you guys are from India and stuff, or all over the country. They come from everywhere in the world, basically, and get on this surface.
The guys from India are the best. Freelancer is a good site to go to if you're looking for anybody to help you with any of that stuff.
Those guys have been expensive lately, though.
Freelance, it's been expensive, has it? Yeah, I haven't used it for about a year, so I've
People
been
know
so
they're better now. They for a while they were just kind of, just I don't want to say it they're just people that come in and you can't trust them. But now they're becoming groups of people, and so they're really doing really good jobs. So people are paying a lot more now.
Yeah, it's a lot cheaper than paying North American got $30 an hour to do it.
Yeah. Okay, well, can we wrap it up for today?
Yeah. Does anybody else have any questions or anything? Okay,
Good for me. Thanks again.
Yeah, many thanks.
Anytime.
Let's do it again as soon as we can. We'll put together some few things, and when people have a good next time, a night or whatever, anybody suggests that they want to get on a call, and we'll do it.
Sounds good. I just fire it out of the group, and we'll get it all happening.
Okay. Sounds great. All right. Well, that's all we need to say on the recording. So that's good. We'll talk on the rest of the
guys.
Cool, nice one. Thanks a lot, guys.